So here's the latest twist in the Logan Paul defamation lawsuit against CoffeeZilla, and it honestly looks like Logan and his team are trying to straight up gaslight the judge. If you haven't been keeping up, things are not looking good for Logan right now. Every new update just makes this situation messier and more intense. For the past few weeks, Logan and his crew have been fighting hard to keep his deposition hidden from the public. And if you don't know what a deposition is,
in the Logan Paul v. Coffeezilla defamation case, the two parties are currently fighting over whether Logan Paul can mark his entire deposition as confidential. And in the last couple of videos that I did on this topic, I talked about how this is actually highly unusual to ask for an entire deposition to be marked confidential. And I talked about how Logan Paul's arguments for why it should be marked confidential are actually really weak.
It's basically CoffeeZilla's lawyers sitting Logan down and grilling him with questions about the alleged scams tied to his name. So the big question is, why is Logan so desperate to keep that footage locked away? Maybe because CoffeeZilla's team didn't go easy on him and it didn't make him look great at all. Does Logan actually have the right to hide his deposition? Not really, yet he's still pushing the court to seal it, trying to steer things in his favor. And with this new update, he's only digging himself deeper into a tough spot. And of course, shout out to Legal Bites for breaking this whole case down step by step. In the last update, Logan laid out 4 reasons why he thinks his deposition should stay private. First, he claimed CoffeeZilla can't be trusted with it. His lawyers argued that if it's not sealed, CoffeeZilla might release it publicly, pass it to other attorneys, or even share it with investigators. And here's the real issue: none of that is illegal at all. Second, Logan claimed CoffeeZilla has been sharing case information with the FBI, and because of that, the deposition should stay confidential. But that argument falls flat fast, because there's no rule saying you can't hand over lawfully obtained information to law enforcement. That's not some shady move. That's completely allowed. Third, Logan pointed to a protective order, saying CoffeeZilla was violating the spirit of it by sharing details outside the lawsuit.
Instead, Paul tries to suggest that the case law CoffeeZilla is citing to says it's actually a more lenient standard than what CoffeeZilla is arguing. Specifically, Paul says defendants' own authorities recognize that the standard for designating non-filed materials as confidential is, quote-unquote, more lenient. And then Paul cites to this case from the Fifth Circuit, Hoali v. Exeter Financial Corporation. But the thing is, although Paul says that there's like this more lenient standard, he doesn't exactly say what that more lenient standard actually is. And there's a very good reason for that. That's because if he did, it would naturally highlight the fact that the one thing that the Fifth Circuit says that Logan Paul needs in order to mark the deposition as confidential is good cause. Specifically, here's exactly what the Fifth Circuit says. In our view, courts should be ungenerous with their discretion to seal judicial records, which plays out in 2 legal standards relevant here. The first standard, requiring only good cause, applies to protective orders sealing documents produced in discovery. And then it goes on and actually says, under both standards, the working presumption is that judicial records should not be sealed. So reading that, the Fifth Circuit is actually pretty clear that Logan Paul's motion should absolutely fail.
But here's the catch. The actual protective order doesn't block CoffeeZilla from sharing that information in the first place. Then, Logan argued that CoffeeZilla gave information to lawyers involved in the CryptoZoo class action case, claiming that was somehow improper. Once again, CoffeeZilla's lawyers shut that down quick, explaining that non-confidential discovery can absolutely be shared with attorneys in related cases. That's standard practice. So when you break it all down, this case is not swinging in Logan's favor. None of his points really hold up legally, and most of what he's upset about are actions CoffeeZilla's team is fully allowed to take. So yeah, it feels like a whole lot of noise in that courtroom right now. Not even sure what all the pounding is supposed to prove. But like Legal Bites pointed out, Logan's team doesn't seem to have much to stand on when it comes to actually defending their arguments in this case. These new responses don't even bring fresh information to the table. It looks more like a distraction play, trying to steer the judge away from the fact that their position is weak. Right now, Logan's team is fighting hard to keep that deposition sealed, and you have to wonder why. Maybe because the video reportedly shows him getting seriously pressed by CoffeeZilla's lawyers.
CoffeeZilla is not a criminal. I called him, I apologized. Step 2, we want to offer a rewards program for players who are disappointed in the status of the game. So essentially you're gonna be able to burn your base egg or your base animal for the mint price, which was 0.1 ETH or the equivalent in BNB. I am personally committing 1,000 ETH to this, which is about $1.3 million. I'm sorry, guys. I apologize for how this has unfolded thus far, and I want people to know that they can trust me and that I'll always take care of the fans and people who support me. And lastly, thank you, CoffeeZilla. You have catalyzed this, and I am very grateful for your work and your investigation, and I mean that. Thank you, bro.
And like I said, the reasons Logan gave for hiding the deposition just don't add up. None of them really stick. The whole situation feels like dramatic table pounding instead of solid legal points. Logan brought in a stack of lawyers and seems to be stretching this case out, possibly because he has more money and resources than CoffeeZilla, instead of directly addressing the core issue. The real question is whether his public statements and actions around CryptoZoo were misleading. But instead of focusing on that, the court has been stuck on side battles. Should the deposition be sealed? Can discovery be shared? Did anyone cross a line?
Whole board.
And the reason this probably came up is because, remember, the judge started out here in this hearing transcript talking about CoffeeZilla's motion to transfer the case. If we look back, in that motion, CoffeeZilla made the argument that the whole reason Paul filed this lawsuit was to purposely engage in funny business. Specifically, one reason was to punish CoffeeZilla, and then the other was to get around roadblocks that came up in the class action case and to gather discovery from CoffeeZilla that he could use in the class action case and during a time when the class plaintiffs weren't able to collect any discovery against Paul. So with that in mind, when we look back at this hearing transcript that Logan Paul has attached to his reply, let's home in on one part specifically. The judge says, "I'm concerned with the team on the Logan Paul side that some of this information would be information that could be used in the other case, even with the protective order." What that means is the judge is actually recognizing that the protective order can't necessarily stop CoffeeZilla from sharing non-confidential information with the class plaintiffs. And then, importantly, the judge immediately also says, and the flip side, of course, anything that was disclosed by defendants in this case to Mr. Paul, how could he not use that in that case? Again, he's saying, how could he not use that in that case? That means he's once again acknowledging, I know I can't stop Logan Paul from using discovery over there after he gets it over here. And so what we can piece together is that the judge here isn't saying, hey, CoffeeZilla, you're not allowed to share information with the class plaintiffs at all. And to be clear, that is actually what Logan Paul is trying to suggest in this current argument over his deposition. But rather, what it sounds like the judge is actually saying here is, I'm worried about all of this just turning into a huge mess where both sides start to abuse the discovery process across the board to get an unfair one-up on each other between.
It's turning into a legal tug-of-war. All this talk about the spirit of a protective order doesn't actually solve the real issue. It just stretches the timeline and drives legal costs higher, which clearly works in Logan's favor. Every extra motion forces CoffeeZilla's legal team to respond, and that means more hours, more prep, and more money burned just to stay in the fight. That kind of pressure adds up fast. But courts have seen this play before, especially when wealthy public figures are involved. And here's the irony. When someone believes their deposition actually helps them, they usually don't go this hard trying to seal it. Pushing this aggressively to keep it hidden can raise eyebrows instead of calming them. Dragging things out might buy Logan some time, sure, but it can also strengthen the impression that the actual facts aren't lining up on his side. That's not a great look. In civil cases, getting something sealed isn't easy at all. The legal standard is high for a reason. Judges don't hide records just because someone asks. There has to be a clear, specific reason backed by solid evidence. Usually, sealing only happens when the material includes truly sensitive details, like private medical records, financial data, or matters involving a minor. And even in those situations, courts usually go for very narrow redactions. We're talking one line here, a small section there.
So here we're talking about how I think that in Logan Paul's reply, his lawyers did some things that can potentially backfire. And explaining this really starts with the weakness of his arguments. Let me put it this way. There's this old trial lawyer's saying that if you're weak on the facts but strong on the law, pound the law. If you're weak on the law but strong on the facts, pound the facts. And if you're weak on both, pound the table. Pounding the table is often thought of as being like forceful or aggressive in your tactics. But I actually like to think of it as any strategy to try to essentially distract from the fact that there really isn't much to your case or your position in this particular argument. But the thing is, depending on your strategy here, you could find yourself in the danger zone with the judge. And I think that is where we just might be in this particular issue. To start, Logan Paul's reply is an opportunity to strengthen the arguments from his original motion. It's supposed to be pretty limited in that it's supposed to be responding to the opposition, but nevertheless, it should be able to use something to kind of bolster it somewhat. But instead of doing that, he basically repeats all of the arguments from his original motion, all of which, like I said, I think are already pretty weak.
Not wiping out an entire document. That's a huge issue with what Logan is trying to do. You don't just seal the whole deposition because you feel like it. He would have to point to the exact page, the exact line, and explain clearly why each part qualifies as confidential under the law. That's how it works. Logan's reasoning basically comes off like, this might be embarrassing or used against me. Please don't release it. But that don't fly in a courtroom. In civil cases, transparency is the default. Courts serve the public, not the other way around. People have the right to see how justice plays out unless there's a serious and proven reason to hide something. And here's where it gets wild. Logan's team cited a past case to argue for a more relaxed standard when sealing records. But if you actually read that ruling, it says something very different. The Fifth Circuit explained that the lower good cause standard applies to protective orders during discovery. Once a document is filed into the public record and becomes a judicial record, a much stricter balancing test kicks in. Under both legal standards, the starting point is clear. Judicial records are not supposed to be sealed. So unless Logan can show real good cause, his deposition shouldn't be hidden. Like any other civil case, it should be public so people can read it, review it, or watch it for themselves. That's how transparency works. It's honestly surprising that Logan's team even filed that response because parts of it seem to back CoffeeZilla's position more than their own. Up to this point, Logan still hasn't presented a solid legal reason for sealing the deposition.
Now, to make matters worse for Paul, his lawyers at one point in this reply tried to do that thing that I described earlier. You know, where both sides will take the legal authority that the other side is using to support their arguments and try to show how it actually supports our side. But the problem is, as much as Paul's lawyers are trying to do that, in my opinion, I think they're very unsuccessful at it. For example, in this part of the reply, they're responding to CoffeeZilla's argument that in order to mark his deposition as confidential, Paul needs to show good cause. And this basically means that Logan Paul needs to have a good, rational reason that has something to do with some kind of privacy interest. It's really not all that hard to do, but the problem for Logan Paul is that nowhere in any of these filings does he ever argue that he has good cause for making any part of his deposition confidential, let alone
the arguments raised so far just don't meet the standard. It's hard to ignore how weak that looks. Logan is spending a massive amount on legal fees, yet the strategy doesn't seem effective. It almost feels disorganized, or like the goal is simply to stretch the case out as long as possible. That delay tactic might buy time, but it doesn't strengthen the legal argument.
At the end of the day, court records are public for a reason. Just because someone has money and a large legal team doesn't mean they get to bend the rules. The justice system is built on accountability, and public access is a key part of that. If court records could be sealed anytime a powerful person asked for it, then transparency would only apply to regular people. That's exactly what the Fifth Circuit is warning about, and it connects directly to the CryptoZoo lawsuit, and even the Pokemon liquid marketplace situation that's under investigation right now. These aren't small, private disagreements. We're talking about cases involving millions of dollars, massive audiences, and thousands of fans who say they were financially impacted. When a public figure like Logan builds a huge business using his platform and influence, and that project falls apart, it becomes a public issue.
This case.
And by the way, not only is this understanding of this issue pretty common across the board in the United States, but the Fifth Circuit is also binding authority on the court that we're in right now with this lawsuit. In other words, the judge in this case is required to follow this case law. And I want to share a little bit more from this Fifth Circuit opinion because I think it beautifully illustrates why it's important for the public, you and me, to have access to this kind of information. For context, this case, Hoali v. Exeter Financial Corporation, involved two parties who basically agreed behind closed doors to keep like 3/4 of the discovery in that case marked confidential, and then to seal it permanently just so that the public could never have access to it after the litigation was over. And by all appearances, they didn't do this because this information was actually sensitive in any way. It's just the parties wanted to keep information private amongst themselves. And so the Fifth Circuit said in response to this, the public deserves better. The presumption of openness is Law 101. The public's right of access to judicial records is a fundamental element of the rule of law. Openness is also Civics 101. The Constitution's first 3 words make clear that ultimate sovereignty is wielded not by the government, but by the governed. And because we, the people, are not meant to be bystanders, the default expectation is transparency, that what happens in the halls of government happens in public view. Americans cannot keep a watchful eye either in capitals or in courthouses if they are wearing blindfolds. Providing public access to judicial records is the duty and responsibility of the judicial branch. Why is this important? Because accessibility enhances legitimacy, the assurance that things are on the level. Article 3 courts are independent, and it is particularly because they are independent that the access presumption is so vital. It gives the federal judiciary a measure of accountability, in turn giving the public confidence in the administration of justice. Put simply, protecting the public's right of access is important to maintaining the integrity and legitimacy of an independent judicial branch. And hopefully, more access to judicial records means more trust in judicial officers and more respect for judicial orders. Judicial records belong to the American people. They are public, not private documents. Certainly, some cases involve sensitive information that, if disclosed, could endanger lives or threaten national security. But increasingly, courts are sealing documents in run-of-the-mill cases where parties simply prefer to keep things under wraps. And so this opinion goes on. If you want to read more from it, which I highly recommend, I am linking to a copy of it in the description below. It's very passionate and very clear about how we shouldn't just be allowing parties to mark something as confidential simply because they want to keep it out of the public's eye. And oddly enough, that sounds like exactly what Logan Paul is.
In the CryptoZoo situation alone, many people say they lost serious money after promises of refunds and fixes that never fully came through. The public has a right to compare what was said publicly with what was said under oath. If a deposition tells a different story than apology videos, tweets, or past statements, that raises major questions. And that could be why there's such a strong push to keep it sealed. It's very possible CoffeeZilla's lawyers asked tough questions like, why did you only refund partial amounts to the CryptoZoo victims? If those answers weren't clear or uncomfortable, that would definitely create pressure in that room. Now Legal Bites breaks down how Logan and his team's own arguments could seriously backfire on them. Sometimes when you push too hard on a weak point, it ends up hurting you more than helping. It really comes down to this. People have the right to see court records. Just because Logan has money and a stacked legal team doesn't mean he gets to bend how the justice system operates. The whole reason court proceedings are public is for accountability. If powerful figures could seal records whenever they felt uncomfortable, transparency would only apply to everyday people. That's exactly what the Fifth Circuit warned about, and it connects directly to the CryptoZoo lawsuit and the Pokemon Liquid Marketplace situation that's under investigation right now. These are not small personal disputes. We're talking about millions of dollars, huge audiences, and thousands of fans who say they were financially impacted. When a public figure builds a major business off influence and supporter trust, and that project falls apart, it becomes a public matter. This is a public concern, no question. In the CryptoZoo situation alone, many people say they lost serious money after being promised refunds and fixes that never fully came through. The public deserves to compare those promises with what Logan said under oath. If a deposition tells a different story than his apology videos, tweets, or public statements, that's a major problem.
That is a problem for them because that would mean that they are twisting the judge's words to the judge. Let's take a closer look so you can know what I mean. So this hearing transcript that Paul attaches starts out where the judge is talking about Coffeezilla's earlier request to transfer the case from San Antonio to Austin so that it can be litigated in the same court as the class action case. And there's discussion leading up to this that we can't see, but he basically concludes that he doesn't want to transfer the case over there. So the judge says at the top of this page, "So I'm wondering, I will tell the parties the motion to withdraw, the transfer to withdraw. I'm not transferring this case to Judge Griffin. It would not be fair. I've already had involvement in this case. He's got enough on his plate. But I am considering staying some or all of the proceedings in this case while that case gets rolling. I need to hear from the parties on it. I'm concerned about it. Judicial resources need to be economized. There is the danger of prejudice to both sides. I'm very concerned, even though there's a voluntary agreement by these potential class members to subject themselves to deposition, I'm concerned that that could be prejudicial to them. I'm concerned with the team on the Logan Paul side that some of this information would be information that could be used in the other case, even with the protective order. And the flip side, of course, anything that was disclosed by defendants in this case to Mr. Paul, how could he not use that in that case? I'm worried. I do not want to prejudice the parties. I need to hear from the parties as to how to address these issues. It's separate from the motions in front of us. I'd like to start with the plaintiff." So it sounds like what the judge is really saying here is, we have these two cases where one person is a party in both of them, that's Logan Paul, and then you otherwise have other people who can be affected in one case by something in another case that they're not even involved in. And so rightly, the judge is worried that there are things that can happen here that could lead to an unfair prejudice to one or another side. And if these parties start to engage in discovery,
that could be exactly why there's such a strong push to keep the deposition sealed. It's very likely Coffeezilla and his lawyers asked direct questions like, why did you only refund partial amounts to the CryptoZoo victims? If the answers were unclear or uncomfortable, that would not reflect well at all. Now, Legal Bites explains how Logan's own filings might actually hurt his position. Once you look closely at the weaknesses in his arguments, the pounding on the table strategy starts to stand out. There are a few moves in this reply that a judge might not appreciate, but one stands out the most. It appears Logan's lawyers may have taken the judge's words and quoted them in a way that shifts the meaning to support their argument. That's a risky play in court, and it could seriously backfire. Bold move. Let's see if it actually works out for him. Here's what's going on. In his motion, Logan Paul pointed to something he claims the judge said earlier. He wrote, "Plaintiff has reason to believe that Mr. Fenderson and his counsel have routinely been sharing discovery material from this case with the class action plaintiff's counsel."
Now, Legal Bites explains how what Logan and his team said may end up backfiring.
So now that we see the weakness in Logan Paul's arguments here, I want to talk about the pounding on the table part. Specifically, here's where I want to talk about what Logan Paul's lawyers do that I think could end up backfiring. Now, there are actually a couple things that Logan Paul's lawyers do in this reply that the judge might not like, but I really want to focus on one of them. And basically, it looks to me like Paul's lawyers may have twisted the judge's words out of context in order to make their argument.
It's a bold strategy, Cotton. Let's see if it pays off for him.
Let me explain. So remember how in his motion, Logan Paul pointed to something that he says the judge said at some point. Specifically, Paul says, plaintiff has reason to believe that Mr. Fenderson and his counsel have routinely been sharing discovery materials from this case with the class action plaintiff's counsel, something this court expressed concern about when it decided to temporarily stay this case, and conduct which, again, constitutes use of discovery materials for purposes other than litigating the claims and defenses in this action. So now when you read this, it sounds like back when the judge decided to temporarily freeze this case back in September, he had this super serious concern specifically about Coffeezilla sharing information with the class plaintiffs. But if you watched my first video on these arguments in this particular issue, you know that I looked back at the judge's September order staying the case, and I saw that the judge didn't say anything about this in that written order. And so in that video, I said, the only thing that I can really think of is maybe the judge made some kind of a comment at the hearing just before this written order came out. And as it turns out, in the reply, we finally get to see that that's in fact where Logan Paul's lawyers are getting the idea that the court expressed this concern about the sharing of information. Specifically, Paul's lawyers attach a very small bit of transcript from this hearing to show this. It's really not enough to get full context on what exactly was being said, but we can basically put together more or less the main gist of it. And the thing is, now that I've seen at least this much of what the judge said here, based on how much I can put together, it kind of looks like Paul's lawyers may have twisted some things here.
So Legal Bias makes a great point, as it seems like Logan's legal strategy is becoming incredibly stupid and
something this court expressed concern about when it decided to temporarily stay this case and conduct, which again constitutes use of discovery materials for purposes other than litigating the claims and defenses in this action. When you read that, it sounds serious. It makes it seem like back in September, when the judge temporarily froze the case, he was deeply concerned about CoffeeZilla sharing information with the class action lawyers. That's the impression Logan's team is clearly trying to give. But here's the twist. If you watch the earlier breakdown of this issue, you know that when we looked at the judge's actual written order from September, there was no mention of that concern at all. Not a single clear statement backing up what Logan's filing suggests. At that point, the only possible explanation was that maybe the judge made a comment during the hearing right before the written order came out. And now in this reply, we finally see that this is exactly what Logan's lawyers are relying on. They're pointing to something said during the hearing to support their claim that the court was worried about information being shared. That's a strategic play, no doubt about it. Specifically, Paul's lawyers attached a very small portion of the hearing transcript to back this up. It's only a tiny slice, not nearly enough to give full context about what was actually being discussed. Still, you can piece together the general idea from what's shown. And after looking at that section, it really seems like something isn't lining up. From what can be gathered, it appears Paul's lawyers may have stretched or reframed the judge's words. Legal Bites makes a strong point here. Logan's legal strategy is starting to look risky. The concern is that his team is presenting the judge's comments in a way that makes it sound like the court already had serious issues with CoffeeZilla's behavior. But when you actually review the written order from September, that specific concern about sharing discovery materials with the class action CryptoZoo lawyers is simply not there in the official document. To support their claim, Logan's team relies on that small excerpt from the hearing transcript. And even that snippet doesn't provide full context. It doesn't clearly show the judge condemning CoffeeZilla or issuing a warning about sharing information. Instead, it reads more like a broader courtroom discussion, not a firm ruling or accusation. That distinction matters a lot. What may have been a small courtroom comment now seems blown up into something way bigger than it really was. And that's why this strategy could seriously backfire. When lawyers reference the judge's words, they're expected to be exact and accurate. If it looks like they're stretching or twisting those words to create a concern the judge never clearly stated, that can damage their credibility fast. From the judge's perspective, this might not even look like a normal legal fight anymore. It could start to feel like someone with deep pockets trying to outmaneuver the system instead of addressing the core issues. And if the judge begins to see Logan not as someone protecting a legitimate legal interest, but as someone misquoting the court and dragging out proceedings without strong grounds, that could hurt his position in a big way. And here's another thing. Isn't it interesting that Logan's team didn't attach the full transcript? We don't get to see the full exchange, how the other lawyers responded, or what arguments were made in full context. That missing piece stands out. Hopefully the court sees right through this and decides to unseal the deposition. If Logan truly believes he did nothing wrong, then transparency shouldn't scare him this much. But if it does get released, we might all get a front row seat to some very uncomfortable courtroom moments. And after everything that's happened, a lot of people feel like they deserve to see the full picture unfold. Now I want to hear from you. Do you think Logan is honestly trying to protect something truly confidential, or is he worried about the internet hearing exactly what he said under oath? Drop your thoughts in the comments below. Don't forget to like, subscribe, and share this video so more people can stay informed. I'll catch you in the next one.